Hello students, I am Assistant Professor Yeshwan Bora and today we'll be discussing about the very popular topic of Indian Evidence Act, that is the Section 6 and the Doctrine of Resgestae. Okay. So in a previous lecture, we have discussed about the types of evidences, again the direct evidences and the circumstantial evidences. So we all know what are the direct evidences, but what are the circumstantial evidences? So in the Evidence Act, Section 6 talks about the circumstantial evidences. Now we'll be moving to the definition of Section 6. It says that facts which though not an issue are so connected with the fact in issue as to form the part of the same transaction are relevant whether they occurred at the same time and same place or at a different time at a different place. Sorry, yeah. So now you will see the facts which occurred or which are so connected with the main fact in issue, as we have got in the definition that what are the fact in issue. If you have like seen the previous lectures, you must have heard about, must have seen about the what are fact in issue. The fact in issues are that the facts which talks about the existence, non-existence, nature or extent of any right, liability or disability which is asserted or denied in a suit will be termed as a fact in issue. So now you will see that all those facts, all those facts which are so much, which are like uh, which are not in the fact in issue, but they are so much connected with the fact in issue, and they form the part of same transaction. Like the person has gone from his house, he has called a person, and he has drove his, like he has driven his car, and all these things, they are the part of the same transaction, and at the last he murdered B. Okay, I'm just giving you the example for the understanding. Okay, and they form the part of same transactions. Are these all facts will be the relevant facts, and again whether this particular facts had occurred at the same time of same place or different time of different places. Okay, now uh, I, as per myself, I have stated this particular definition in 2 points. Okay, in 2 points, how you will see that facts which do not in issue are so connected with the fact in issue as to form the part of same transaction are relevant. Now this is the main point of this particular thing. Okay, now after that I have divided into two parts, whether these particular facts are occurred at the same time or same place, or whether this particular fact are occurred at the different type of different places. Okay, so this is the a definition which is given under section 6. Now we'll be moving to illustration for the better understanding. So you see the illustration, it says that A is accused of the murder of B by beating him. Whatever was said and done by A or B or by the bystander at the beating, also shortly before or as after it, as to form the part of same transaction, is a relevant fact. Now you will see, you must have seen some incidences also on the road, that there is some accident by the person, and after that accident they argue with each other that it's your fault. No, some like other party will say that it's your fault. Okay, so they will be playing the blame game, and in the blame game, sometimes it becomes so violent that people start beating, like the parties, they start, they let that the violence, or you can say that the arguments led them into fight. So all these things which have been said or which have been done during that particular in that particular act will be the part of same transaction. Okay, now I and will be the part of same transaction, and again it will be the relevant fact that whatever the person has said in the particular transaction, like again I have given you example of that road accident or road rage, and that people are saying no it's your fault, no it's your fault. Okay, so all these things which have been said during that particular time will be the part of same transaction. Okay, and these all facts will be the relevant fact. Now moving further, you will see the res gestae. Okay, now what is res gestae? People always say that res gestae is this, res gestae is this, but you'll see that res gestae, uh, they generally talks about the psychological facts. Now again, in the definition of facts, I have told you there are two types of facts. One is physical facts and other is psychological fact. Okay, so res gestae, the doctrine of res gestae has been borrowed from the English law, and it is like incorporated, or you can say included in under section 6. Okay, and as I said, it is a psychological fact, and it goes like this, that the psychological facts, though not in issue, are so connected with the fact in issue and as to form the part of same transaction occurring at same time and same place. Now you'll see the main definition of section 6. You'll see that there is a same time in same place plus different time and different place. But again, if you go in the res gestae, you will see that there is only a definition. In the definition, only same time and same place are included, different time and different places are not included. So that means that all the psychological facts which are not connected in the fact and issue, but they are so much which are not in the fact and issue, but they are so much connected with the fact and issue as to form the part of same transaction. And if they are like, let's just say, I'll say that they are very spontaneous, you can say, and they are very like, they should be not be they should be like spontaneous, and they should be at that particular time only. It's not that they got the lot of time, and after taking lot of time, the people are like, the person or parties are saying that, then it will not be included in the register. Now moving further, you'll see that what is the difference between res gestae and hearsay evidences. As we all know, hearsay evidences are not admissible in the evidence act. Why? Because hearsay evidences is the statement which is stated by a person who has not himself witnessed the happening of a transaction. Okay, but he had heard it from the others. Okay, now you'll see that you must have heard that someone has committed a theft in A's house. Okay, now you have heard it from someone that he has committed a theft in A's house. Now moving further, the person will say to another person that I heard it from that person that this person, like in this person's house, theft was committed on that particular day. Now you see in my statement only, there are so many fluctuations or additions in that particular statement. That is the reason hearsay evidences are not admissible under the Indian Evidence Act. And again, why it is not evidences? Because these statements which are given by the person, okay, uh, is not like, he has not himself seen that particular transaction or that particular act, and he has heard it from someone else, and that is the reason it is not admissible under the Indian Evidence Act. Now moving to the res gestae, they are admissible because they are made under the influence of some principal transaction and are so connected with the fact and issue. Now if you will see the example that some person is committing like A is committing murder of B, then in that case, whatever as we say saw in the illustration, whatever things have been said by the B during that particular act, and if in case if there is someone standing and witnessing the whole act, okay, in that case, whatever the person has seen, that is about the bystander, will be coming to that in a further slides. Okay, whatever it has been said, whatever it has been seen by the bystanders or the person who has witnessed whole a crime, then in that case, his deposition or his statement will be calculated or will be included under the res gestae. Okay, but only the psychological fact, you see, only the psychological fact and not the physical fact. Okay, now moving further, I have taken some examples. Okay, now the first case law. Sorry. Now the first is whether the statement of the prosecutrix amounts to res gestae or not. Now, in the case of Gulam versus R, and it is the very old case, R means regent, okay. It has been said that where a girl who has been raped and made a statement to her mother after the rape, when the culprit had gone away and the girl came home from the scene of occurrence, it was held not to be admissible under Section 6 of the Indian Evidence Act. It is included in the Section 157. Now you will see that whatever that in this particular case you will see that the girl has been raped and he has like the he has she has been seen by her mother in front of her house, and when her mother asked her what had happened, then in that case she replied that she was victim of rape was committed with her, and because of that particular thing her mother filed lodged an FIR, and she gave her statement that I heard it from my uh, daughter that she is a victim of rape and rape has been committed with her. So, in this particular case, the court held that this deposition or the statement which has been given by her mother under is will not be calculated or will not be included under section 6, or you can say under the res geste, okay, and it will be included under section 157 of the Indian evidence, which talks about the former statements which have been given by the witnesses to prove the testimony of the you can say the act or the person, okay. So now moving further, you'll see the next case flow that the contents of FIR when amounts to register, okay. So in the case of Shyam Nandan Singh versus State of Bihar, its citation is 1991 39 BLJR uh, 12 98 1991 CRI that is Criminal Law General 3350. So you'll see that it has been held that if a witness is present at the crime at the scene of occurrence and he sees the whole incident, he sees the whole incident from beginning to end and makes cry about the offense being committed, and then after some time goes to police station and files an FIR, then the making of the report is a part of same transaction and amount to register. Now in this particular act you will see that the person was witnessing the whole crime from his what you say from his terrace, okay. And then in that case he had again shouted that roko ise bachao ise ye karo wo karo. You have must have seen that many times people shouting about this thing, and then after some times he like not after some time, like it will not be the like the major time lapse between them, but yes, after that particular incident he went to the police and he files an FIR, okay. Then in that case that particular report will be the part of the same transaction and it will be amount to register. Now I think that you must have heard like you must have got the concept of the circumstantial evidences and the res geste. In case if any doubt you can just write in the comment box and you can ask me, and I like take your leave right now and see you in our next lecture. Till then take care of yourself and study well, and thank you.